All right. Dan's getting up here and getting set up. I'm going to do just a quick little introduction to frame this panel, and then I'm going to turn it over to them to talk about their various areas of expertise. So their biographies are in your materials. I'm so excited to have all of these gentlemen here, whom I've known at least for a few years for various different reasons. I think they're the perfect group of people to talk about how we can understand these issues in more depth. So Professor Marcus, Professor Ho have worked on administrative law issues generally and applied a lot of analysis to them in other contexts. And I think they have a lot to talk about. Judge Ray had a very key position within the Social Security benefits appeals process and really brought them into the 21st century and completely changed the way they operate using big data and machine learning. And I think there's a lot of potential there that I'm excited to hear from him. And then Phil Carter here has worked in the political space and the question of, okay, once you want to do something, how do you actually make it happen? How do you coordinate the stakeholders? How do you convince everybody that this is the change that needs to happen and we ought to get behind it? And I think he has a lot of insight into what is the potential that solutions are going to come not from the federal courts, but through the other democratic branches of government. And so with that, I think the perfect framing for this, and I know Dan's chomping at the bit to get started, is the CAVC just issued an en banc decision in a case called Monk, which was a class action to deal with delays at VA. And I think the fundamental position of the courts in denying the class action motion at that time was, we don't want to wrap our arms around the entire problem and just take general ownership of it. We expect the advocates to identify specific problems with specific solutions and build classes around narrower categories and ask for orders to make specific changes. And so if that's going to be the approach of the federal courts, that we have to deal with these issues in a granular way with specificity, then that raises the question of how can we understand them? How can we dig inside this? And with that, I think Dan is ready to talk, and I can't wait to hear from him.
Thanks so much, James. I'm delighted to be here as part of such an esteemed panel. I'm going to present some joint work with Dave Marcus from UCLA. I will first provide a little bit of academic context for what BVA is facing, and then I'll talk a little bit about some research findings that really speak to the point that James had mentioned about what the BVA can help us understand about administrative law more broadly. It's work, I teach both administrative law and statistics, and one of the kind of basic problems of governance and due process that has obsessed the field of administrative law for the better part of 50 years is the challenge of accuracy and consistency in mass adjudicatory or enforcement systems when you have complex law and highly decentralized decisions. So 3 quick examples. One comes from the immigration context, where there are about 300 immigration judges that determine whether someone is eligible for asylum. Cases are randomly assigned within an office, and the asylum grant rates can vary from as low as 5% for one judge to as high as 95% for another judge, leading some scholars to decry this simply as a form of refugee roulette. Example number 2 comes out of the Patent Office, where there are 9,000 patent examiners tasked with determining whether an application is useful, novel, and non-obvious. And one oft-quoted phrase about the Patent Office is that there may be as many patent offices as there are patent examiners. Last example that Judge Ray will talk about at length involves the Social Security Administration, where here I'm just presenting the award rates of ALJs in the Bay Area from a number of years back. Again, cases are close to randomly assigned within an office, and one leading study in this field concluded that outcomes depend more on who decides than on what the facts of the case are. And I think James quite nicely framed it, which is that if you look at the quarterly case counts of the number of BVA decisions over time, they're here. You see this dramatic kind of spike in the last fiscal year. And one of the basic questions is whether the sharp increase in the caseload will compound this basic problem of accuracy and consistency of decision making, or as some BVA attorneys have expressed, they simply don't have adequate time to review the record before them. And for administrative law scholars who've sort of thought about this for quite some time, and the leading work really comes from Professor Mashaw at Yale, who studied the SSA system in great detail in the 70s and 80s, and came to the conclusion that judicial review, at least from his perspective, was not the kind of basic answer for this, and rather concluded that the way to deal with this is through management. And so he famously concluded that due process requires management processes to assure the accuracy of claims adjudication. And the sort of challenge in the field for some time has been that we've actually had very little information about what kinds of management systems and what kind of quality assurance systems work well. And so I'll tell you a little bit, and this gets back to James's broader point about what the BVA tells us about that question of whether quality assurance and quality review can in fact solve that due process problem that Professor Mashaw kind of talked about. So what we looked at is the quality review program that the BVA ran for the better part of 15 years. The way it works is that a team of full-time attorneys, 4 to 6 attorneys, randomly sample 5% of original decisions, 10% of CAVC remand decisions, and review them before the opinions are issued to identify whether they're substantive legal errors, and write exception memoranda to identify what revisions may need to be made to improve the quality of the decision. And the key one, sort of internal memorandum describes defines what a substantive error is that should be called by a staff attorney as a deficiency that would be outcome determinative, that is, result in the reversal or remand of a board decision by CAVC. And that's because the express purpose of this program was to improve the rate at which cases would be affirmed at the CAVC. The interesting thing to note in light of what James has told us about the increase in the caseload just over the past fiscal year is you have an increase in veterans law judges, staff attorneys, and the number of cases decided, but the reported accuracy rate out of that quality review process is, if anything, that the accuracy of decision making has increased over time. And so we looked at this in more detail, and kind of from wearing my statistics hat, one of the really nice things about this is that you have random selection of cases, which allows you to actually compare those cases that went through the quality review process to a really credible control set of cases that are comparable on every single dimension that we can look at. We've got procedural history, the service period, issues, diagnostic categories. They're the same, and it's a large sample. There's about 600,000 cases that are eligible for quality review during this 15-year time period. Here's the basic finding. The effect of quality review on whether or not the case was likely to be appealed is 0. That is, there is a 6% chance that a case gets appealed to the CAVC for the QR cases, as well as for all of the other cases that could have been selected for quality review. And given an appeal, there is no difference whatsoever in the likelihood of a reversal or remand based on whether or not the case went through this quality review process. 3/4 of cases are vacated and remanded regardless of whether the case went through the quality review program. And you might ask yourself, why is this the case? Well, we can rule out kind of 2 explanations pretty easily. We don't think the data actually supports the idea that CAVC decisions are simply too unpredictable, or that VLJs are simply refusing to read and revise their decisions in response to these exception memoranda. Really, the right answer lies in the kind of administrative law answer, which is that the standard of review that was on the books for some time, for the better part of these 15 years, really changed over time. And so here is how one official articulated it. The standards of quality of review have loosened up over time. The standard that we used to be following was essentially whether CAVC would be likely to vacate and remand. We moved off of that standard quite some time ago to a lesser standard. So much so that in a revision in 2017, you could only call an error when the error was undebatable. And to give you just a sense of what that means, is if the quality review team during this 15-year period deemed a case to have no legal errors, a clean bill of health, in that set of cases, 74% are still vacated and remanded by CAVC. Right? And so we think that this is a really important thing to keep in mind, because if you look at the accuracy rate over time that's reported out in the annual reports by the chairman's office, it remains pretty stable over time. While what James showed you is the FTEs have dramatically risen over time. One way in which you can actually start to get a handle on whether there is a genuine effect on quality, not through this accuracy measure that really changes because the standard review is changing. One way that we did that was to actually grab all of the opinions from the CAVC and look at the rates at which joint motions of remand are issued, which are essentially, as we understand, a kind of settlement agreement between a different part of the VA, the Office of General Counsel, and the claimant's attorneys. And you can see that at that rate, you're going from a period of time where the rate at which JMRs were issued was as low as 40%, and in the most recent fiscal year, as high as 72%, which we think is probably the better evidence on the state of the accuracy of the board's decision-making over time. And with that, I'll turn it over to Dave Marcus to talk about what can be done about some of this.
Oops. So this doesn't paint the prettiest picture of quality review at the board, and it begs the question of whether successful quality review is possible. And we think the answer is yes, that it's not, that successful quality review is not impossible, nor is it a luxury that an agency can ill afford as it struggles under the weight of crushing backlogs. An innovative program that Dan helped to design and test for food safety inspectors in Seattle-King County illustrates what can work. Food safety inspectors and VLJs actually share similar jobs in certain key respects. Both types of officials have to administer a detailed, complex body of law, but a body of law that nonetheless leaves considerable room for the exercise of individual discretion. Both sets of officials render decisions under considerable time pressure. King County conducted a randomized controlled trial to test a quality improvement initiative that was rooted in peer review. The trial assigned half of the inspection staff to a peer review group. Inspectors in this group were partnered with each other once a week. An inspector would review a facility. The partner would then also review the facility, and they would score them independently. This redundancy revealed deep inconsistencies in the exercise of adjudicator discretion. Put simply, inspectors disagreed almost 60% of the time. Data from these inspections revealed the violations that caused the most confusion and informed training for these problem areas. The peer review group met weekly to discuss what they were learning. By learning from each other and from the targeted training, inspectors assigned to the peer review group grew much more consistent over time. So you can see the dramatic improvement in consistency between the treatment group, the peer review group, and the control group. The increased consistency came mostly from inspectors who had previously been reluctant to cite violations. In fact, it boosted their citation rate by about 20%. Meanwhile, inspectors in the control group remained just as inconsistent. The King County initiative did not use quality assurance to generate a blunt overall measure of accuracy, but to give feedback and guidance that reoriented decision-making. Since the mid-2000s, SSA, the Social Security Administration, has institutionalized quality review in its now in its Office of Analytics, Oversight and Review. It has designed several programs that share some of the features of the King County experiment. A good example are its program of focused reviews. Several indicators, including an ALJ's disposition and remand rates, can prompt a team of attorneys to review that ALJ's decisions intensely. This review reveals recurring concerns. Supervisory personnel can then devise targeted interventions, including counseling administered by peer ALJs and focused training. SSA can also use the information gleaned from these focus reviews to inform training and the development of policy more generally. This information, as well as information gleaned from its other quality assurance initiatives. The experience of SSA, which like the board struggles with immense caseloads, is promising, and we'd love to conduct a rigorous examination of what it's done and what works. This and our examination of the board's program more generally prompt a last question. Under what institutional conditions can a quality review program best succeed? To our mind, the first condition involves transparency. At the least, an agency should make the metric it uses to evaluate quality and the data necessary to test its program's efficacy public. In August, the board reported an accuracy rate of 95% for its decision-making in 2018. This figure, the board declared, is, quote, consistent with the board's historical average over the last 20 years. But as Dan mentioned, the error standard that the quality review team uses to spot errors has changed over this time. Whatever meaning the 95% figure has unto itself, the historical comparison strikes us as particularly questionable. Without information about the metric and relevant data, the results of the agency's program are difficult to interpret. Even better, an agency should be willing to experiment with pilot evaluations to test what works, with input from and participation by outsiders. The second condition involves independence. Those performing quality review need to have sufficient institutional authority. They need to discharge their duties without fear of any possible repercussion, and the feedback and guidance they generate needs to be well received, not resisted by those whose work they review. Staff attorneys at the board review the work of VLJs who are superior officials in the agency hierarchy. This setup creates at least two problems. First, will attorneys on the quality review team worry about their relationships with VLJs and call fewer errors as a result? Second, would a VLJ take umbrage at feedback from a younger, less experienced colleague? The third condition involves stakeholders and oversight, and possibly even court intervention. In its annual reports, the board has reported a 90 to 95% accuracy rate for 20 years. As far as we know, Congress has never seriously questioned this accuracy number or expressed much concern at all about decisional quality more generally. If oversight committees credulously accept a self-reported accuracy number generated under opaque circumstances, then an agency has an incentive to stick with the program that yields the number, whether it is meaningful or not. As we've asked our interview subjects, why does the board keep reporting such a high accuracy rate even as caseload pressures increase? Wouldn't a concession that backlogs are having an effect on its ability to generate high-quality decisions help the board make its case for more resources? The response we've gotten is consistent with what the public administration literature would predict, which is an agency is unlikely to go to Congress and say, we're struggling to do our job, so please give us more resources to improve. Without effective oversight, an agency may lack an incentive to subject its own quality review program to sufficient internal scrutiny. Related to oversight is stakeholder involvement. Stakeholders are important for several reasons. VSOs, for instance, can press for effective oversight of the quality of agency adjudication. Doing so may mitigate the churn that James mentioned, the churn of cases going up and down that so many veterans have to endure. Also, with quality review designed the way we prefer, stakeholder involvement can be crucial to ensure accountability and good results. The point of quality review isn't to come up with some overall grade. The point is to help adjudicators improve, even as they work under significant caseload pressures. King County and SSA have used data gathered from their programs to identify particular problem areas and devise targeted responsive interventions. Stakeholders can help the board do the same. Outsiders, including academics, VSOs, the GAO, and others, can help the board devise programs best designed to detect particular areas of concern where VLJs make the most frequent and costly errors. These groups can likewise help the board design and test interventions to help VLJs decide more consistently and accurately while also meeting case completion goals. Finally, it's worth thinking about judicial intervention. Systemic quality and agency adjudication is not just a matter of good public administration, it's a constitutional obligation. The federal courts have been reluctant to engage in synoptic engineering when it comes to agency processes, but an order requiring meaningful quality review might be necessary to vindicate this constitutional obligation. At the least, reviewing courts should look for concerning trends in the appeals that they review and not hesitate to comment on what they're seeing. Doing so could also prompt changes within the agency. That's our work thus far. Dan and I are in the midst of continuing to develop this project. We would be delighted, very much delighted to hear from any and all of you if you have insights or perspective that can add to what we've come up with so far. So thank you very much.
Okay, I want to thank James for inviting me today. I'm really pleased to be here, so I do thank you for setting this up and for inviting me to be here. I did not bring any slides with me, but I will talk about what we did at the Social Security Administration, because I think there are a lot of parallels between what happened at SSA and what has been happening at the VA. And I think when I look at what's going on at the VA, it strikes me that their policies are somewhere where the Social Security policies were back in the 1980s. We started getting hit with class actions, in large part because we didn't have a lot of clear policy on how to articulate rationale and decisions. We didn't have a lot of requirements for that. We simply told our judges to consider these different issues, but didn't tell them how to do that. And the court started sending cases back to us en masse with instructions about how to do that. So we actually had to change our policies to bring that up to speed. More recently, I think the VA has built a new system. I think it's called CaseFlow. That's turned their cases from a paper process to an electronic process. We did that at Social Security in the early 2000s. A few things that we did that they haven't done is we've gone further than that. We built case analysis tools, different types of templates for decision making, and a variety of other things that I'll talk about. One thing I do want to mention is something that James brought up. He noted the problem with addressing a complex system, and that if you tinker with it, you may not get a better result. I think there's a lot of truth in that, but I also think that complex systems were constructed. And so if they were constructed, they can be deconstructed, and if you deconstruct it well enough, you can solve all the micro problems that you're faced with. And so I viewed all of what we did at Social Security as a series of micro problems that had to be solved. And so if you want to move toward improving quality, and you want to improve timeliness, and you want to improve productivity, you've got to deal with all of those problems as micro problems. And so that's kind of what we did. And the Appeals Council at Social Security, where I worked, we were the last step of appeal. So we were getting appeals of hearing decisions. There were as many as 1.1 million hearing decisions that were pending just a few years ago, actually. And there were about 170,000 cases pending at the Appeals Council. We had a staff of about 1,200 people to do that. We were putting out about 80 or 90,000 cases a year with that staff. Since 2009, they cut the staff of the Appeals Council by about a quarter, but we doubled productivity and eliminated the backlog. So I'll tell you basically what we did to achieve that, and it was a whole series of things, some of which the VA probably could implement today, some of which will require some thought and some development of some technology to move forward with the more complex areas of this. So one of the first things we did, I think the VA already has sort of performance metrics for their staff. We did not have performance metrics for our staff, so we developed an algorithm to do that. We basically looked at how many hours in casework people were spending and how many cases they were doing, and then figured out, and we broke the cases into 12 categories in which we had some data. Figured that the cases were not all of equal complexity, that some cases are harder than others. So we weighted the cases, and we did a sort of an iterative math process to come up with some performance metrics, which then when you applied those to the staff, you found it was sort of a distribution of productivity, and you set a lower boundary, and everybody below that had to step it up. We weren't interested in taking adverse action against people, but we were interested in making sure everyone was working during the day. So we felt we needed to retrain some of those people and get them up to speed. We actually didn't have to take too many adverse actions, but we did get the people up to speed. So they picked up their productivity. The people who were near that baseline for successful performance also picked up their performance because they didn't want to be seen as sort of near the bottom. The only people that didn't really increase their productivity were the high performers, and we had a significant number of them, and we put in a metric so that they could be rewarded with cash awards, with outstanding ratings. Another thing that we noticed was that all of our staff wasn't necessarily doing the job that our budget staff thought they were doing. So you hired attorneys to write decisions, but the local managers were having them, write policy or give training or do other things. And so some of those things are valuable. But we actually looked at all the PDs of all the staff and tried to push off as much of the work that wasn't casework as possible to other staff, which freed up more staff time to do more work. So these are pretty minimal things that can be done just by local management. But that gave us more staff, and it gave us a little bit more productivity. We also then looked at what motivates people. And one of the things we found is people like to become expert at what they do. And the more expert they are, the more likely it is that they'll be higher performers. So if you want people to be experts, how do you get them to become experts quickly? So we looked at our training and how adults learn. And what we were doing for training at the time was we had lecture-based training, something like what I'm doing today, where someone stands up and tells you things, and then you only remember about half of that when you walk away. So it isn't the most effective way to teach people. We also found that we were mostly teaching on what the business rules were and not necessarily how they should be applied. And when you look at how adults learn best when there's some context added to their learning. So they learn how to apply whatever it is you're teaching them. So we threw out lecture-based training. We don't use that anymore at all at the Appeals Council. We had sort of a proctor come in and we have examples and we opened cases on day one. We used to have 8 weeks of training and we didn't open a single case in training class. We simply talked about the rules and we turned people loose with mentors who maybe were good and maybe were not. And they learned how to do the job from their mentors. That's a pretty haphazard way to train people, but we did that for 60 years. So we got away from that, though, and we started using some of these newer techniques. So in the training class, we started doing cases. We cut the training class from 8 weeks to 6 weeks. We found that people are more productive, fully productive in about 5 months after they come out of training class. It used to take 18 months for them to become fully productive with their mentors. So it was a huge pop in performance right out of the box. We also got rid of using mentors and started having people, when they came out of training class, work in small groups. They'd have 4 people work on the same case. They would then discuss it with the judge. And so they would discuss with themselves to come up with one solution to that helped them teach each other how to do the work effectively. After 1 month, they cut down to 3 people per group and then down to 2, and then eventually you're on your own. And so after 5 months, the people were fully productive. So that worked actually quite well. In the process of this, we developed about 4,000 pages of new guidance that we were able to then also put online. I'll talk about that in a few minutes. We also push training to people because we want them to maintain the knowledge that they have and to learn things that they don't know. It is a complex program. We had actually mapped out we'd made a decision tree of our policies to map it out to the about 2,000 different outcomes you can have in a Social Security disability claim. It's almost exactly 2,000. So we actually did sort of a decision tree of the policies. We found a lot of problems with some of the policies that were very open-ended. You could get multiple results with certain policies. We had a few policies that were actually conflicting. If you use this one, you got this result. If you use that one, you got a different result. We found that to be somewhat problematic. And I think having more grounded policy that gave more clear instructions about how to do the work, we saw that as a generally a good thing. It also helps down the road as you start doing things like natural language processing. I'll talk about that in just a few minutes. I know that the VA has built a tool called CaseFlow to replace VACLs. I think I mentioned that already, but when we built our electronic case management systems at the Appeals Council, we also built in what we call a case analysis tool. And the case analysis tool used that deconstructed policy. Then we built it into a sort of a flow chart, and we simply asked the reviewers questions about the decision. So when they were looking at the case to review the case, they would have to answer certain questions in this tool, and as they answered those questions, we captured structured data. So we were actually capturing structured data about the quality of the work. And not only did that help the employees move through the analysis process faster and better and more consistently, it also gave us data that we could then use later to build smarter systems. We built a tool called the Findings Integrated Template. This was simply a sort of a Word document generating system that had a specified template for decisions and described where you would put rationale in if you made certain types of findings. If you made a finding, you then had to add some rationale. and the rationale is needed to withstand appellate and court scrutiny. So that helped also with the quality of the work, simply having that tool. That tool was not integrated into our electronic case management system and case analysis tool. It should have been. It was built as a standalone, and I think the agency is going to integrate those in the next iteration. But that is something that's quite helpful for people who have to write lots of decisions in short amounts of time. It's good to have a structured format for doing that. So that's something else that we did. The case analysis tool, as I mentioned, captured a lot of structured data, but we also had this training, all these training modules that we developed. So we built an online tool called How Am I Doing? That tool passed information back to adjudicators about the quality of their work, the quantity of their work, the processing time. It gave them lots of information about them specifically. It gave them information about all the cases that were found to have errors that had been remanded to them. And then gave them a 3-tiered training module. The first tier was simply almost like a desk guide, like a 2-page desk guide you could print out that sort of said what this type of problem is, how you can avoid it, what the policy is, and what you should be doing, and how to avoid making a mistake in the future. And then the second tier of it went to the actual training guides we used in training class, giving them a lot more material on how to do this stuff correctly. And the third tier was a direct reference to the policies, the regulations, the rulings, and the Social Security Act that related to that particular problem. This was self-guided training. So a lot of times when you're looking at quality in the government, they often put that into rating systems. And so it becomes sort of a game of gotcha. And I didn't see it that way. I know we had to actually put that in our rating systems, but I wanted to push information to people to help them become expert. I wasn't interested in figuring out how many mistakes I could find. I was interested in trying to teach them to not make mistakes in the first instance. And so by not having that stuff flow through their manager, they weren't being gigged for these errors per se. They were simply getting this opportunity to improve the quality of their performance. And it was fine with me if they got a good rating. As long as they did a nice job and understood exactly what it was we wanted them to do and did it well. So that's kind of the approach that we took to that. In terms of what Dan and Dave were saying earlier about the quality assurance, we also had a quality assurance review that did a national random sample of cases. We reported to Congress year in and year out that their quality was 97, 98% accurate. I didn't believe that for a second, having been an adjudicator and having looked at 40,000 cases or so in my career. I found lots and lots of errors. So we set up our own division of quality. We got our staff to go faster. I mentioned I kept losing staff, but we kept going faster. And so I was able to carve out about 60 people, and we set up our own division of quality. And one of the first things I did was I looked at the quality of the quality assurance review that the agency was doing. I pulled the exact same cases that they looked at, where they found 98% accuracy, and I found it was, our reviews showed it was 73% accuracy. So I went over and talked to them about that, and they acknowledged, they actually looked at those cases again with our reviewers and acknowledged that we were essentially correct. They didn't really find any point in which we were wrong. So they changed their accuracy rating from 98 to 97 that year when they reported to Congress, because we had only looked at those 400 or 500 cases or something. We hadn't looked at every case. So therefore that wasn't reflective of what was going on anywhere else. It was simply those cases. We later got them to, after the manager there was replaced, they did then change their quality metrics that they were reporting after that, and actually started then adopting a lot of the approach that we were using. As Dave mentioned, we started doing focused reviews. So the notion here is, again, I want people to learn how to do this stuff correctly. So we would look at a large number of cases from an individual and then give them direct feedback on the types of problems that we're finding. Again, pushing this training to them, trying to get them to not make those errors in the future. We did see a significant convergence in the allowance rate actually over time. We'd seen previously that the allowance rate was climbing by about 1% a year. That's actually why I got into this quality issue. I didn't think that the conditions of the population were such, that the medical conditions were such that the disability rate was actually going up. I just thought we weren't necessarily doing the cases correctly. The allowance rate actually fell because one of the things we did was we did quality assurance of favorables and unfavorables. and there hadn't been a lot of focus on the favorable decisions. It's one of the ways you can bring a backlog down is you can pay all the people who come in front of you. As James said, you can wait for them to die. You can also pay them all. That's another quick fix, but it isn't necessarily the correct fix. My view on that is you're giving someone a disability check, in the Social Security disability program, you're taking them out of the workforce, and they're not very likely at all to go back into the workforce if they leave the workforce. And so you're relegating them to a much lower level of income for the rest of their life. And it isn't really doing them a service unless they actually need that disability benefit. So I thought that was not the way to go. I think most people in the agency also thought that was not the way to go, but it wasn't something that was being really monitored effectively enough. So we started doing that, and we saw a big change in that allowance rate, which had an effect on the trust fund. It's billions of dollars a year that was being spent of money that the agency had taken in. I think the allowance rate is a lot closer to where it should have been. I remember back in the early 80s, Congress was concerned about the high allowance rate at that time. I think it was around 39%, and they passed the Bellman amendments and asked us to look at favorable cases. Well, the allowance rate, when I started looking at it in 2009, was about 61%. I think now it's around 44%. And I think that's a pretty fair number in terms of the population that we see. I think that seems to be true. Now, we did also find when we were looking at this data, we found a few instances where people were seeming like the judges may be colluding with some of the attorneys and some of the doctors. And we referred those to the IG, and we had some people arrested and thrown in jail. There was some fraud that was found as a result of some of these efforts. And also, of course, there were some whistleblowers and things that came forward. But there's not very much fraud in the program. We didn't really see a lot of that. We did see outlier behaviors, which we mostly attributed to people developing their own heuristic model of how to do the work. So if you don't train people well on how to do work, they start coming up with their own version of how to do it. And their own version, if they don't get feedback, after a while, they think they're doing it correctly. And they actually think they're good at what they do. And when you then give them feedback, they're like, what are you talking about? I've been doing this for 20 years. Yes, you've been doing it wrong for 20 years. Not a message that too many people want to hear. So they're not initially not receptive to that, but it's the truth. And so if you could show them and sort of explain to them what they should be doing, and ideally what you'd want to do is you want to train them with that information at the outset. So that was sort of the training initiatives they did, but I really want to talk more about the things we've done since then. These are things now that I don't think the VA is really positioned to do yet, but could be. So one is I think they need to make their policies what I would call Boolean, so that you have choices that are made by the decision makers that, it's true, false, yes, no, this and that, this or that, if this, then that, those types of things. So you can sort of program this stuff into natural language processing and use machine learning and artificial intelligence. And we did move in that direction at Social Security. So I captured all the structured data from our case analysis tool, which that's something I think that the VA could certainly very much use. If they had a tool that captured information about the quality of the work that was being done, you can then use that information to start to build sort of some AI to help you and assist you in adjudicating these claims. So one of the things we did was we used sort of a free software called Python. And I wasn't able to hire data scientists and computer scientists because I was an appellate body with judges and attorneys. So I asked for that because I thought data analysis would be really helpful for us, but they wouldn't let me actually hire any. So I begged and borrowed a few people from around the agency. I just called people I knew and asked them to help. And then I did hire attorneys who had computer science, math, and economics backgrounds. And I simply put them to work with me to develop a lot of these things that we did. Before I get to the NLP part, I do want to mention that in order to try to go a little bit faster, we did start using some statistical analysis and econometric analysis and techniques like probit analyses and clustering analysis and semi-naive Bayes analysis and things like that allowed us to identify characteristics of claims that were similar and characteristics of claims that were likely to be dismissed or characteristics of claims that were likely to be paid. We could actually score cases on the likelihood of an allowance. So without ever opening the electronic folder, without even looking at the folder, we could run algorithms against it and say this case is a lot like cases that are paid 97% of the time. So you could pull those out and you could screen those cases. And if you gave them to people who were somewhat expert, they would pay the ones that should be paid, and the 3% that shouldn't have been paid, they would of course continue to deny. But it got you to a screening operation that was actually pretty effective, and you can move cases more quickly and still do them accurately. We also were able to batch cases by similarity. And so, as I mentioned earlier, there are about 2,000 different types of outcomes in disability claims. So if you're an attorney working for us and you're doing, say, 400 of these a year, many of these different types of scenarios you don't see for years, if ever. But if you got a batch of cases that were very similar, then once you work through the problems of solving that first case, the second case is a little bit easier, and the third a little bit easier, and so on. So if you did them in batches, and if I batched them in such a way that you and all your colleagues in the branch with you were working on the same type of case at the same time, when you had water cooler conversations, you could actually, you'd all be at about the same place in terms of your thinking about these cases, and so it's even faster for you to talk about cases with your colleagues. And so we did that and batched cases and found that actually, not only did it cause about a 12% pop in productivity, but actually caused about a 7.5% increase in quality. And actually, the number of errors dropped because people were doing cases similarly, and they realized, oh, I should do this and not that, and they talked to their colleagues who were doing similar cases at the same time. So those types of things can really help, and the VA might be able to do some of that now with the data they have. I don't know exactly, I haven't had a chance to look at any of their data, but a data scientist could certainly help them with that. So then moving on to the more recent thing that we did, so we did actually bring natural language processing and machine learning to the table using Python, and we used things like regular expression to find terminology, relevant terminology, in the decisional language, fuzzy string matching to find spelling variants and typographical errors and realize that that's the same kind of stuff. Co-reference resolution, which helps you find other words, phrases, and notations that have the same meaning. Named entity recognition to classify the text with proper names and deduce whether this is the name of a person or the name of an organization. So different types of applications like that were put into place. I also had the Division of Quality staff curate a bunch of decisions and look at language that was policy compliant and policy non-compliant as sort of examples, as sort of a training set for the people who actually wrote the program. We then implemented this program, which is called Insight. It reads the hearing decisions. We built this at the Appeals Council, again, with just attorneys. I didn't have any systems support for this at all. We built it and implemented it at the Appeals Council. And it finds about a third of the remandable errors, just straight up, about a third of the errors. The very first iteration that we put out can identify about a third of the errors. So then we talked to systems and we thought, well, maybe we should push this back to the hearing level where they could run this before they issue the decision, because when I run it on a review, I've got to send it back with an error on remand. As it turned out, the servers that we had didn't have the right math coprocessors, and so they weren't able to do that initially, but they have just recently, I think, rolled it out in a few test offices, and they are getting new equipment so that they can run this in the hearing level. The next generation of this, in my view, is to start reading the medical text itself. It's a harder problem for a number of reasons. One is some of the reports are handwritten, and it's difficult to have a machine actually figure that stuff out. But even on the stuff that's typed, there's a lot of pieces to this, and it's going to take quite a bit of time. But I think at some point we will have some AI ability to actually read the medical evidence, which would be very valuable at the initial level in Social Security, where cases are done pretty quickly without all of the robust written explanations that are required of the judges in the appellate level for review by the courts and on appellate review. So I do think that is the future, and we will, the agency will go there. I won't, because I've retired. But I think the agency is going to move in that direction. I hope they do this wisely. And if they do, I think it would be a great benefit. And I think if the VA did these types of things, they would start to see a significant reduction in their pending backlog. I think they'd have less cases returned to them from the CVA, and I think they would have, if their staff had better quality and better performance and better understanding and training, they would go faster. If they had these decisional tools like the case analysis tools that would help them work faster, and then the natural language processing and so on, I think would make it all go a lot quicker. But I do think they're going to have to work on their policies a little bit. They're going to have to build some of these tools. These tools don't take very long to build. We built the case analysis tool in about 2 years. We built the natural language processing in about 1.5 years. So this stuff can be done. The policies, they take a couple of years too, because you've got to work that through OMB and talk to Congress and so on. But with that, that's pretty much what my remarks are, and I'll pass this over to Philip.
Thank you very much. And I should apologize up front. I sometimes joke that as an Army veteran, my service-connected disability, or one of them, is PowerPoint. And I forgot to bring PowerPoint slides today, so I feel a bit bereft. But I do want to talk about some of the broader equities in this space. And I want to talk really about 3 or 4 broad points that we leave with. One is the enormous population change that's underway in the veterans population. 2 is the change in the social contract of service with America's veterans. 3 is just how hard the VA is to manage, and the way that certain agencies interact with their iron triangle, if you will, on reform issues. And 4th is something of a cynical point, which is that politics often trumps good ideas, logic, or data in this space. So population first. The veterans population is under enormous strain right now. It's changing a great deal before our very eyes. In 1980, the veterans population sat at about 28 million. That included cohorts from World War I a little bit, World War II, Korea, Vietnam, and the Cold War, and then the continuing cohort of veterans from the current force. By 2010, that population had shrunk to 23 million. Today, it sits at about 21 million. In another 2 decades, it'll shrink further to 14 million. The sizing construct that matters is the size of the military, not whether we're at war. We've been fighting this war for the last 17 years with a relatively small military, and assuming we keep the size of the military constant, which is likely because it's a very costly force, the veterans population will continue to shrink, and shrink as a percentage of the American population as well, because the American population has grown enormously during this time. At the same time that this population has shrunk, it's also changed internally significantly. So I was just talking with a friend of mine about the aging of this population over time. We've now essentially seen the World War II segment fade from the scene. The same with the Korean War cohort. The Vietnam War cohort is right at about their peak age for utilization of VA healthcare and benefits. Median age is something around 66 or 67. That's also, by the way, the median age for the veterans population. So just bear that in mind when you think about the needs of veterans today. The median age for the population as a whole is roughly 65. And that's driving a whole lot of demand across the board for veterans benefits and services. My generation, the Iraq and Afghanistan generation, is hitting the system at the same time that this massive Vietnam War and Cold War conscription-driven cohort is also hitting peak demand. And so a lot of the data that James showed and that we've been talking about today is the result of those twin tails of the age distribution hitting the system at the same time. Query whether this demand will continue much beyond the next 10 years as actuarial trends take their place, and as we see that sort of mouse go through the python, if you will. So second, changes in the social contract. Today's VA is the result of 200 plus years of evolution. I think, James, you talked about the Newburgh conspiracy and what happened at the end of the Revolutionary War. Well, I usually start my history at the end of the Civil War with, this first massive cohort of veterans that comes online, lobbies successfully through the Grand Army of the Republic for pensions and benefits and so forth. We see the establishment of soldiers' homes and a number of other things around the country. But it's really after World War I that we get the modern VA as it exists today, through the creation of the Veterans Bureau and the passage of War Risk Insurance Act and a number of seminal statutes in the 1920s that set the die for what exists today. It also created some implicit assumptions in the system that the VA would not just exist as it had for the nation's first 150 years to serve just the service-connected injured population or the seriously ill and injured population or the indigent population, but to serve all veterans, and to do so with varying degrees of service that over time became quite comprehensive. And so by the end of the 1920s, we see a veterans health system emerge and a veterans benefits system emerge that serves all veterans, does so with an increasingly generous array of benefits, and does so in many cases whether or not those benefits are service-connected or not. I'm sorry, that those maladies are service-connected or not. This continues to expand after World War II with a huge cohort of 16 million veterans from that conflict, and grows with each successive conflict because our nation has, I think justifiably, but it's arguable, become increasingly generous towards veterans, and not just through the addition of support, but also additional types of programs, home loans, educational support, and not just educational support for all veterans, but vocational rehabilitation, and on and on and on. One of the things that I think has driven this is the emergence of perhaps the most powerful iron triangle on Capitol Hill, maybe even more so than in defense contracting and other spaces, and that's the iron triangle of veterans benefits. Veteran service organizations, the VA, and veterans themselves constitute an incredibly powerful constellation of interests that have over time advocated successfully and policed a system of VA benefits. And this was on display a number of occasions in the last few years. In 2009, when the Obama administration took office, it looked at the issue of service-connected presumptions for Vietnam veterans and decided, based on the broader equities of the situation, the fact that Agent Orange had been litigated for decades without conclusive result, and the fact that actuarial reality was taking its toll and that these veterans weren't going to be around very much longer, to go ahead and grant service-connected presumption for a number of injuries and illnesses relating to Agent Orange and lots of other stuff too. That had a huge effect on the claims process and a huge effect on the healthcare process as well, because as soon as veterans became entitled to disability compensation, they also shot up in the priority group scheme for healthcare and began to utilize veterans healthcare at greater rates, which then arguably had a huge impact on healthcare utilization that resulted in things like the Phoenix Access Crisis of 2014. At the same time, in 2009, Secretary Shinseki came into office and realized that there was this huge category of veterans who did not necessarily have access to the healthcare system because they were in priority groups 7 and 8. They did not necessarily have a service-connected disability. They did not meet the means test, but for the equities of the system, the VA ought to open its doors to them. Those doors had been closed for resourcing reasons in 2003 by then Secretary Principi. Secretary Shinseki opened those doors, allows priority group 8 veterans to come back into the system. Again, huge impacts downstream on the resources of the VA and its ability to meet its promise to those veterans that it has historically felt as core, those with service-connected injuries, but has increasingly come to serve all vets. So changes in the social contract of service, increasingly serving all vets, but also we see the impact of politics and a desire to serve more and more veterans is trumping what the agency is resourced to do or statutorily commanded to do first. The last point I want to talk about briefly is the role of the VSOs in this space. So veteran service organizations have existed in some form for quite some time. The biggest ones came online first after the Civil War with the Grand Army of the Republic, United Confederate Veterans. Those effectively vanished by World War I, but they were replaced by the Veterans of Foreign Wars in the United States, the American Legion, Disabled American Veterans, each of which was founded during those seminal moments. Well, VFW goes back to the Spanish-American War, but they really became super empowered after World War I. These VSOs have played a quixotic role with respect to claims and appeals over the last 70 years. They are deeply invested in the system as it exists today. Their raison d'etre is to help veterans navigate a friction-laden process. And so in some ways it could be argued that it's in their interest to maintain the friction of the process because that provides the role for their claims officers and their advocacy arms. They are also interested in serving their members. They recognize that their members benefit from a smoother system. And so in 2016, when Patrick was involved with veterans benefits reforms, these groups played both sides of the table. They were part of the process to reform the system, but in the VFW's words, they were an active member in a series of meetings, but participation does not imply consent or approval of a new process. And there was for these groups a very deep distrust of the agency born of decades of agency litigation, obfuscation, opposition, and so forth over issues ranging from atomic veterans to Agent Orange to Gulf War syndrome to on and on and on. So the politics of this space are incredibly contentious, and the VSOs who have a lock on Congress and a lock on the public imagination play a vital role and oftentimes a very adversarial role. It's unclear in the current political environment whether the opportunities exist for change or not. And I'll just close with the observation that in the fights over private purchase care for the VA healthcare system, the VSOs have continued to play a very complex role in this. They have advocated for veterans' interests, but it's not at all been clear that they and the VA are on the same sheet of music as to what is the best way to serve veterans. And it is unlikely, absent some scandal or forcing function like another claims backlog explosion as we saw in 2013, that we'll see an alignment between the VA, veterans organizations, and Congress in the same way that we've seen during previous instances of change. So thank you again, James and Adam, for having me, and look forward to the discussion.
All right, Adam, I don't know if there's a microphone around. Oh, great. So, I mean, I got a few prepared questions to fill time, but really we've got plenty of time here to answer some questions about what it is that we know about the process and what it is we might want to know. And I see at least one question up front here for Victoria at the middle table, and we'll go from there.
Hi, thanks everyone for fantastic presentations. I have two questions for Gerald Ray. I'm really interested in the reforms at Social Security. And my first question is, are Social Security's decision-writing attorneys part of a union?
Yes, they're part of 3 different unions. Yes.
Okay, so it can be done with a union. That's great to know.
The judges also are in a union, in the hearing level.
Lucky judges. You mentioned that after management was replaced, they started to adopt our approaches. And so I'm interested in what kind of changes, other than obvious receptivity, you saw in that willingness to adopt the approaches. What kind of preconditions are required before these changes could be adopted?
So as a general matter, when I would first approach the agency with something that we were doing that was working at the Appeals Council, I would get pushback saying, well, that only works where you are. That wouldn't work anywhere else, which isn't really the case. And it took me a while to start winning people over. And so, the quality assurance people, it wasn't really that we had to change a lot of managers there. The person who was responsible for reporting simply didn't change the reporting, and then that person moved on. And the quality assurance people then realized that what we were saying was basically correct. So we didn't have difficulty there. I think where I had a lot of success was at the commissioner level, where the commissioners were very interested in bringing data analytics to the table to try to drive things forward to move into the 21st century. And I think there's more dragging of the feet by people under them who are used to doing things the way they've always done them. And so there was, this sort of a pushback of, well, we've never done it that way, or that wouldn't work, or it wouldn't work here, or something like that. But eventually, we kept showing examples of how it worked and how things were getting better in our part of the world. I had even difficulty driving us down to the hearing operation, but more recently, the hearing operation has adopted most of these techniques, and their pending has fallen from 1.1 million last year to about 900,000 this year. So they've turned the corner, and it's coming down pretty rapidly. And the quality is still, I think, pretty good, across the board. We're not doing it by paying down the backlog. The commissioner actually took one of my recommendations was to try to put together the data analytics people with some of the people who are responsible for the quality assurance and some of the people who are responsible for the policies, and put them together so they can develop synergies. Because you see from reviewing the cases where the problems are, you can see that with the quality assurance that helps you write the policies. The data analytics are important to all that process to figure out what actually is going on. So she set up a new group called OERA, which is, I don't even know what it stands for.
Office of Analytics, Oversight and Review.
Yeah. So she basically put these components together to do that, took the Appeals Council away from what used to be ODAR, which is Disability Adjudication Review, and moved them over to work with the data scientists in the agency. So once people start seeing that something works, they're a lot more inclined to move toward it. When you just have an idea and can't show the result, I think you get a lot more pushback. I think new ideas aren't something that people are looking for, or not invented here kind of a thing, so we're not interested.
All right, Tom?
Thank you. Thank you, everyone. My name is Thomas Banzel. I'm an attorney for Veterans and Military Families for Progress. And I have two questions, one for Judge Ray and one for Judge Ridgway. Your Honor, the statement that you made about VA not being able to implement some of the things that you recommended, and believe me, I think you are talking about the solution that VA truly needs in looking at the larger picture. So my question to you is, what is the largest single roadblock to that, to the implementation of at least getting on the pathway to bring about change? And my question to you, James, is in the analysis of quality, it seems like they were setting the measure and then trying to support the data underneath it for the objective. Is that really the way that quality should be measured? Because the school that I went to with Dr. Demings taught a different formula, so I'm not really sure if I understand that correctly. So.
Do you want me to start? So,
Thank you.
I think one of the core, there's two really things they need to do. So one is they've got to capture some more structured data. So they just have moved to this new case flow system. They're getting a lot of data there, but they're not getting a lot of case data necessarily from that. It's more management information data. So they have to start developing case data. So I think they need to develop something like a case analysis tool, which would not be that difficult if their policies are constructed in such a way that you can build a decision tree. And I think that was a problem that maybe the digital services people found difficult, a difficult problem to resolve. So I think you've got to kind of look at the context of the policies and see how you can map that, and then try to build a case analysis tool. And I think if they do that, then they'll progress very rapidly toward where Social Security is. And I think those are the major drawbacks that I see.
And I think to try and answer your question in terms of should you be setting quality, I think Gerald's ultimately right that if you're going to do it in an effective, actionable way, you need the underlying process to be Boolean, so there aren't disputes as to whether or not something is right or wrong. The challenge for the board throughout its history is just the amount of subjectivity built into these questions that it deals with in terms of competing medical opinions and rating standards that are phrased in terms of mild, moderate, severe, moderately severe. And if that is your context and you're trying to develop quality metrics, it is very different to be in the position of a judge at the Court of Veterans Appeals where your opinion matters because it trumps, versus being in a quality office where there's a subjective standard and you might have a different subjective view, but it's really hard to set it up in a way where you can objectively explain why your subjective opinion is more likely to be correct than somebody else's. And that, I think, has always been the challenge, is that there's so much subjectivity in the underlying standards, it's very hard to get to a place where you're actually producing actionable information for people on the ground, that if you do this instead of that, you will get an outcome that's going to be affirmed and not vacated.
Those are the very policies I was talking about too, actually.
Just to jump in there, I think the real backdrop to this is that the Government Performance and Results Act requires performance measures, and that's the target that was set right? It was in the lower 1990s. It changed a little bit over time. And so I think one way of reading this relaxation of the standard review really is that as the caseload kind of increases, is you kind of, there's some informal pressures to kind of modulate that, essentially to make sure that you actually meet the performance target that's set out under the Government Performance and Results Act. And I think that's the challenge here, is that if you've got these dual incentives of a performance measure versus measuring quality really to try to systematically improve in the way that Judge Ray is talking about, those push you in different directions of what a quality review team is doing. And that's what I think is the really important thing to get right first, which is that if there's an honest picture of this quantity-quality trade-off, which most folks who understand the system really think is likely to be the case, then the kind of impasse that Phil is talking about in terms of Congress being aware of the kinds of trade-offs might start to change. I think up until this point, the publicly reported quality rates would make you think that everything is all rosy, and we don't think the evidence really supports that.
You get the mic, sorry.
Got the mic first. I'm just going to make the observation, because I serve as an ALJ for the Social Security Administration, and Judge Ridgway's statistics pointed it out. It stuns me that the BVA does not have the ability to issue a final determination in a case. It has to remand it. And I think, and if you extrapolate that onto what happens at Social Security Administration, and I think Judge Ray, who I believe has remanded a few of my cases over the years, the administration would grind to a halt in months if we had the volume of cases we have, and if we had to remand them back to the district office for a determination as opposed to issuing a final determination. And it's sort of a structural issue. Getting my head around those numbers you talked about, I just don't see, I don't see any magic why the BVA shouldn't be able to do those decisions.
Yeah, and that goes back to a principle in statutory law called the right of one review on appeal. And so one of the things that happened in this electronic claims world is all of a sudden the board had visibility on new information that was arriving in the file that in the past would have gone into a physical drop file at the regional office, and the board would have looked at this file and just issued a final decision. But now they're in a world where when you log in, you can see that there was new correspondence uploaded last night. And even if you had a decision on your desk to sign, which happened to me when I was there, you may have to hand it back to the attorney and say, well, now there's new information and we can't issue a final decision because it has to go back. And it's a consequence, not necessarily of what the law was originally intended to do, but all of a sudden what technology makes happen when you suddenly have visibility of all of the new stuff that's flowing in that before just was hidden in the field.
I'll just mention Social Security has a sort of a soft closure of the record, and that actually is what deals with that issue. We don't completely close it. I mean, you can always submit new evidence, and if it's new material, we'll look at it. But we don't send it back, for the initial level to look at over and over and over again, and that's problematic.
Hi, I'm Jeff Lovers from American University, and it strikes me that there are two big differences between SSA cases and VA. One is that the VA has the sort of benefit of the doubt for the veteran aspect of it, and the other is that Social Security decisions are binary. They're either disabled or not disabled, whereas veterans' cases can result in partial disability. I'm just wondering how those two variables affect the decision-making process and the quality review.
So I'll start with that one, and maybe James or others want to jump in. I think that those are core differences. I mean, there's no question there's a big difference in the way it's done. We do in Social Security also sort of, in a close case, I think we'll find the person disabled if it's really close. So there is some benefit that, well, it kind of is, because it's a liberal application of the law, and we train everyone to do that. So, and I think that's part of why the allowance rates are maybe a little higher than they otherwise might be. If you just looked at it totally objectively. I do think that the rating system where you can get percentages is significantly different, but I don't think it's so different that you couldn't also do the same type of approach with that. So you need to define, what constitutes a 10% disability and a 20%. You need to get a common understanding of that, and it needs to be in your policy and your procedures. And once you have that and you train people and so that they all reach sort of similar subjective conclusions, and develop similar heuristics, they'll reach similar results, and your quality assurance would assist with that. So I think it starts with how you've constructed your policies.
So I might jump in and also say that the two systems are fundamentally different based on the political overlay that applies to these populations. The nation would, I don't think, ever tolerate discussion of allowance rates in the same way that Judge Ray is talking about for veterans. And we should also think about the ways that conflict has changed, the ways that different populations have endured different problems as being part of the conversation as well. And this, I think, goes to the desires of the system from Capitol Hill as well. Their interest is not necessarily in an efficient system from a cash perspective. Veterans benefits come out of the great pot in the sky for the Hill's perspective. And what they want instead is timeliness. They would rather see a generous system than a stingy system. And what they really, really don't want are veterans groups knocking on their door saying the system is doing their members wrong. And that's fundamentally different from how we feel about SSDI beneficiaries and their role in society and what we might expect of a system for them and who is going to advocate for them as well. And I think that really does affect the landscape here and the extent to which we can expect a reform system to come out of this.
I'll speak to that on maybe just the technical side, because we do actually have a project with a PhD student at Stanford that is applying the similar kinds of techniques of natural language processing to predict outcomes. And it is actually pretty straightforward to predict whether or not, based solely on the text of a BVA decision, that decision is likely to get appealed to the CAVC. That's something we would love to work directly with folks on, to actually, it'd be the kind of thing that you would want to get in front of the decision makers to know, hey, this draft decision that you have has a 90% chance of being appealed to the CAVC. That seems exactly like the kind of tool that might focus folks on in the drafting process on what to potentially correct. So while there are these really considerable differences, at least in terms of some of the technological solutions, I do think that they're portable.
And the one comment I was going to make is my gut instinct is that this is a more complex system, but that question itself is one that is subject to analysis. And Dan, a professor in Michigan who's done the analysis of the United States Code in terms of categorizing the amount of complexity in there, like you can actually do your own analysis of the number of rules in the system and the interactions to reach the question of how is the complexity compare, and then what could you do to reduce that? And there's other folks that I follow who are not here that tackle that question. I know Brian's been waiting to ask one.
So piggybacking on that whole colloquy, a more pointed question in the same space to you or anyone who would know, because it's kind of how other areas of law compare to VA. Does Social Security Administration in disability benefits have a duty to assist?
Yes, absolutely.
What is the content of that duty?
So, I mean, we realize that many of our claimants don't actually have representation. So the claimant has a burden of establishing they can't do their past relevant work. And they simply have to tell us, that they're being treated and what conditions they're being treated for, and we will develop the record for them. We'll send them consultative exams, we'll get the evidence from their doctors. We'll pretty much do all of it. In fact, even on appeal, you can simply file a pro forma appeal, I disagree, and we will look to see if there are issues that would warrant remand or reversal. So that's a very, very important part of what we do. It's one of the multiple hats that we wear as judges in Social Security, is we assist the claimant in pursuing their claim, because our goal isn't to deny or pay them, it's to get the right answer.
To what extent, and I genuinely don't know this, to what extent does that continue on appeal? So like a new cycle of development activity is required potentially late in the process.
At every level, yeah, at every level. And in fact, one of the things that we were looking at when I left the agency is we were seeing an uptick in dismissals. And notionally, we believe that you shouldn't dismiss a case if the person is disabled, even if they didn't follow all the rules in getting to the hearing or submitting the evidence or timely doing stuff, because it's a disability program, you're supposed to pay the people who are disabled. So they were using some of these econometric techniques to identify those cases, the ones that should have been paid that were dismissed, and pulling those cases for sample review, for own motion review by the Appeals Council to actually reverse those actions and take the right action.
Thanks.
Did you have your hand up? Or no, there's one back there.
Hi, my name is Chris Babick. I'm in the Mason Veterans Legal Clinic. I'm a fourth-year student at Mason, but I also happen to be a supervisory patent examiner. I've been with the office for 14 years. A lot of the charts you were showing up there and the graphs, they looked awful familiar to me, going up with the backlogs. We're doing better, but I wanted to comment. I have a question then, but I wanted to comment on the quality assurance aspect. I'm on the front lines of quality assurance feedback at the examination level. And I wanted to say it does help. I've seen it improve examiners' ability to apply the law and apply policy. What it's not doing is helping them with the ability to synthesize all the other information, in our case, the prior art, but with the VA, the medical records. And Judge Ridgway, you mentioned that they continue to get larger. And we need to apply those same machine learning technologies and AI to help sift through these massive files, because I think we take for granted that somebody who can apply the law can also have also has the medical knowledge to go through all this stuff. You learn it as you go, but that's the biggest stumbling point for my examiners is when they come across a technology they may not be very familiar with. They spend a lot of time searching and a lot of time going through the references. In the VA's case, it would be going through the medical records. So maybe we need to install another level of experts that just synthesize information from factual files and from the facts, and help somebody who is applying the law help them as a fact finder. My question is, with regard to mental health, do you think that a proliferation of mental health claims are now contributing to the increase of the backlog? Because now there's so much more awareness with mental health claims, and would maybe, given the unique nature of those claims, would maybe putting them on a separate docket help speed the process along?
I think there is probably some contribution of that, and I think we could look at the diagnostic code data in vehicles to actually quantify that. I think separating it out in terms of a specialization starts to get hard, because it becomes difficult to tease them out from other things. So you can't understand them always in isolation. Oftentimes, mental health conditions are exacerbated by physical conditions or caused secondarily from physical conditions. And so the conversation of, can you get efficiencies by specialization, whether it's full-time specialization or the type of clustered assignments of work that Gerald's talked about, I think get more difficult within VA, because there is not just the binary question, can this person work or not, but then you could have all sorts of different types of medical issues come up. And even if you specialize in, say, mental health, this one may have a kidney issue as well, and this one may have an orthopedic issue, and you kind of have to be a generalist to handle the tough cases. So there's a role for specialization, but I think it gets to be a more complex problem about how you balance specialization as well as knowing the breadth.
And 2 data points from the claims data of the VA. One is that musculoskeletal wounds and kind of non-specific injuries and illnesses, particularly gastrointestinal, far and away lead the pack in terms of the injuries and illnesses presented to the VA in the disability process. And those are things for which there are better diagnostics than mental health. That would probably be where to put the emphasis in terms of tightening the shot group, if you will. There has been some study of whether there is fraud or game in the system coming in on the issue of mental health, and the most recent analysis I saw from CNA suggested that there was very, very little of that. And for what it's worth, the other data point is that the number of contentions per claim has been going up significantly over the last 15 years or so. That the classic story is World War II veterans, 2 contentions per claim, Vietnam veterans, 4 to 5 contentions per claim, post 9/11 veterans, 8 to 9 contentions per claim. And that, to James's point, really increases the complexity of what's coming up on appeal to the point where it's maybe not even possible to disaggregate these.
And I just want to underscore what you said about the patent examiners. When I spent some time talking to some Social Security ALJs a few years ago, and they mentioned the shift to electronic medical records as a major challenge, just because the records are so much longer. One of the reasons why I was skeptical of the why I think I was interested in looking at and a little skeptical of the board's accuracy rate being so stable over time is just thinking about, well, if records are expanding the way they are in Social Security, then there's just so much more material for a staff attorney and a VLJ to sift through, and the likelihood of overlooking something surely is increasing. If that's the case, then shouldn't the accuracy rate be affected? And so this is all to say I agree with your intuition.
And
Yeah,
Patrick, sorry.
I just wanted to follow up just to draw out one point on the because I think it's a nice connection to draw to the patent side. There are these pilot initiatives. I think it was called Second Pair of Eyes, where they're doing forms of peer review within the patent office, and at least the kind of suggestive evidence from that was that people really benefited. Now, I think from it wearing kind of my academic hat, I think those are the kinds of initiatives that need to be rigorously evaluated so that we know where the best return on investment is, because they're not cheap. Right? You're basically doubling up on patent examination, and so it would be really useful to know what the kind of return on investment is there. As you probably know, the PTO also has a request for information out. I think that was posted just a week and a half ago for trying to figure out what the right forms of machine learning are to identify prior art. So I think that's, again, you'd want to compare which one is the more effective way of kind of training 9,000 patent examiners. One other vehicle that's kind of interesting there that would be used is interesting in the patent system is that there's a third-party submission system where third-party scientists can actually submit prior art. It's a different form of peer review where you can actually leverage scientific insight just as the same way that peer-reviewed journals do it, and that's another way of infusing some more evidence into this process. And we're working on an evaluation. Actually,
It is, but it's increasing the file.
Yeah,
and it's increasing the information they have to look over.
And I don't want to eat up our break, but I know Patrick and Michael have both been waiting to ask questions. So why don't we take those two, and then we'll go to the break, and then we'll be around to answer questions individually.
All right. Good morning, everybody. My name is Patrick Littlefield. Great panel, by the way. I'd like to respond to Judge Ray's comments around Booleanizing your policies, which seems to me to be a foundational element if you're going to move into kind of what I call new models of production. And the question of the panel is, what does that look like in terms of VA and its policies, and to what extent does Booleanizing the system create a deterministic model, and how would that interact with a system where benefit of the doubt is a central part of the the policy objectives of the system? So question initially to Gerald Ray,
Okay.
what did that look like? And then how is that applicable to VA, and where are the differences, and how might we be informed by that?
So we weren't trying to replace judgment with our policies and with our natural language processing. What we're trying to do is make sure that people follow the policy compliant pathing, that they reach all the appropriate inquiries, and that they respond to those inquiries in an appropriate policy compliant fashion. So if you're supposed to address this issue, you need to address it, and there's certain possible outcomes of how you would address that, and you have to choose one of those. So we're not trying to direct you that you must always choose yes or always choose no on each of these, but you must choose one of those, right? You must make a decision on each of these policy compliant points, and that's what we were trying to drive toward. So you can have a lot of different outcomes at each of these points in this decision tree, and they will guide you down to a policy.
So not deterministic.
Correct.
And I think in terms of what that looks like at VA, there's sort of multiple different stories you can tell. There's one story where it's more similar, where you can take a lot of data and figure out your problematic policies and clean them up and make them much easier to be consistent on. But that involves politics sometimes if you're going to be changing substantive law, and that can be really hard. And then there's the kind of nightmare scenario that Professor like Danielle Cintron points out, where you leave the policy the same on the surface, but you write computer code underneath that effectively takes medical opinions with checkboxes and processes them through and offers suggested opinions, where you've essentially changed the law underneath the hood to be Boolean and to be data-driven, but you can't see that from the surface, and you're immunizing it from judicial review and notice and comment rulemaking and all sorts of other things, where we've seen on a state level things blow up because it was done that way, and it turns out somebody got a line of code somewhere and there was a whole class of cases that went wrong, and then all of a sudden we realized what happened, and then that, even though it was the easy way to do at the time, there's a whole big cleanup to do. So I think there's sort of a back and forth between doing analysis that informs good decision, but then being transparent in terms of we're going to make the standards more consistent and ultimately focus the human beings on the judgment questions that only human beings can make in a transparent way where they have to give reasons that can be reviewed.
I do think just one brief point of fact is that the U.S. Digital Service, when moving into several other agencies, did actually consider, should we build a turbo tax for complex decision making? And part of that involved talking to all of the kind of decision makers and essentially coming up with that decision tree. And that process itself can expose significant disagreements as to how to exercise discretion, and that can be a real point of contention that can prevent you from getting to the kind of clear decision tree, but it's also helpful because it articulates more precisely where points of disagreement and agreement might be about a field that's as complex as veterans law.
And then Professor Wishney, and then we'll call that a break.
Thanks so much for this panel. What a fantastic conversation. So two questions to invite anyone to comment on. The first is one of the reforms, Judge Ray, that you talked about that didn't get quite as much attention in the Q&A were the training reforms. As an educator and one who teaches students by doing and working in teams and in peer-to-peer learning situations, I'm curious to hear a little bit more about how some of the training initiatives that you described might and already do exist in the VA. And I say that prefaced importantly by saying, in my own view, delays in the VA appeals are not primarily the fault of or a problem of bad VLJs. Nevertheless, to the extent that there are improved training opportunities to learn from SSA. I'm curious to hear a little bit more about that. The second, this has mostly been a conversation drawing on Social Security and a little bit immigration, the other massive federal adjudication system. But state workers' comp systems in many ways are even closer to the VA, injured workers deciding were they injured in the workplace and how injured are they. And I wonder whether there's more learning to be done from recent reforms in high-performing state workers' comp systems that might be useful here as well.
I mean, I guess I'll start from the back end, which is I've long thought workers' comp was an interesting analogy. I think part of the problem is that it happens not in Washington, D.C. So I'd love to meet the people who do this and have those ideas, but I haven't met them. I don't know that Gerald does either.
Yeah,
in terms of the training question, I do think it's hugely important. And I think, as you know, from my perspective, that a lot of the variance is not stubbornness or maliciousness or anything. It's just inability to tell that you're an outlier or that other people are doing things differently. And so focusing training just on creating not just understanding of the black letter law, but visibility about where you fit within it. I think so you were able to move Social Security from 20% of people being statistically significantly outside the norm in their outcomes to only 3%, mostly just by making them aware that on this issue, you're doing it differently. And then when they think about it, they realize, oh, maybe I shouldn't be different, or they can start a conversation that brings everybody much closer together.
And we took the view that everybody is trying to do a good job. And to the extent that they are doing a job, they think they're doing a good job. So if I can actually get them to actually do a good job, that was really the goal. So when you're looking at quality assurance, we weren't looking at it in the aggregate of 97% accuracy. I'm looking at each individual. Are you doing the best job you can do, and how can I help you do a better job of what you're doing? And try to get them all to sort of understand the commonality and how other people are viewing these same issues and dealing with them. And I think that works pretty well. I think it would work in the VA. I don't know if they've done that. We started doing that in the Appeals Council and Social Security. We won a couple awards from what they call the Deming Award from the Graduate School USA. And then the agency liked what we were doing, our Office of Learning, which is our training group. They started doing this in other parts of the operation, and they also won some Deming Awards. So it works pretty well. We use a lot of feedback. We use Likert surveys, whatever they are, each day in a training class to make sure people understand what we were teaching. So we have them rate whether they understood the materials, whether they liked the way the material was presented, whether they actually understood the lesson. And if the answers to those things were no, we would actually retrain with a different group of people and some different materials the next day if we had to, because the goal is, again, for them to learn, not for me to teach. So that actually worked pretty well. Those surveys also helped us with the training.
In the food safety kind of example, that training element turned out to be critical. So getting the peer review group together to look at tough cases, we had pictures, and everyone kind of would vote and then talk about why they diverged. And actually that was the process by which to build out the decision tree when it came to thinking about the 800-page model food code that exists and how to actually translate that into practice. It's essentially a form of Langdellian case teaching for food safety inspections, and I think that was a really important part of the intervention.
All right. I'm sorry, Adam. We went long. I'll turn it back to you.